A new class action complaint filed today by the D.C. ACLU accuses the Trump administration of illegally targeting government employees for their race and their sex, and then firing them for their perceived political views.
We believe that there was an assumption made that women of all races, non-binary employees, and people of color generally were under some cloud of suspicion, that there was this idea that they were somehow opposed to this government and that there should be reasons found to get rid of them.
Joining us now with her exclusive reporting, NBC News' Yamish Alcindor and MSNBC legal correspondent Lisa Rubin. It's always hard when you put an apostrophe after the S and then have to say it out loud. Yamish, thank you very much for being here with us and bringing us this reporting. Lay out the argument.
Well, good afternoon, Katie. Today, my producer, Fiona Glisson, and I broke this story after talking to federal employees who feel heartbroken and betrayed after years of working for Republican and Democratic administrations. One worker, Sherelle Pyatt, tells me she comes from a family who worked for the U.S. Postal Service for 4 generations. She and others told me that they believe they were targeted by the Trump administration because officials made assumptions about their beliefs as women and non-binary people who had in the past worked on DEI issues. Here's what the workers and an ACLU lawyer had to say. Take a listen.
I am prepared to move forward to show the American public and to show the legal system that we were targeted.
I remember saying, I'm not working in the Office of Diversity, Equity, Inclusion, and Accessibility anymore. Like, I have a role that is not DEI related. They said it doesn't matter.
People are just not allowed to be fired on the basis of their political beliefs or the perception that they have political beliefs that are opposed to the president.
Now, President Trump has said his anti-DEI executive orders are aimed at undoing discrimination, but this class action complaint alleges that those executive orders led officials to disproportionately singling out federal workers who were not white men for hostility, suspicion, job interference, and even termination. These workers, who told me they love their jobs and want to serve the public again, are asking to be reinstated to their previous positions and to be compensated for wages lost and other damages. Katie.
All right, Yamish. Lisa, let's talk about the legality here. Do they have a case?
Katie, they very well could have a case here. And I think a lot of that will turn on these diametrically opposite views of what the law requires. Because oftentimes when a worker says that they were discriminated against, the response is, of course not, you weren't discriminated against. But here, the response is going to be, not only were you not discriminated against, but the reason that we fired you in the first place is because you had a history of participating in what we consider discriminatory action, that is DEI programs. And so you've got the government on one side and these workers on the other with dramatically different interpretations of what the law and even the Constitution may require in terms of non-discriminatory behavior. And that's where I think the ACLU has been particularly clever in also saying they weren't just discriminated against on the basis of sex and race, they were discriminated against on the basis of their perceived political affiliations. Because these are people who had historically worked in a DEI function, even if they didn't anymore, there were assumptions being made about their politics that were unfair to them and unlawful, and therefore they should be restored to their job. They also did one more smart thing, Katie, and that was filing with the Merit Systems Protection Board, which is a federal agency set up to handle the workplace complaints of federal workers, instead of filing in a federal district court. A number of federal district courts faced with similar complaints from federal workers have said, you know what, actually, you don't belong here. Where you really should have brought your complaint is with the Merit Systems Protection Board. ACLU bypassing that argument altogether and going straight there, Katie.
What's the timeline for cases like these? How quickly can they move through the courts?
Not particularly fast. The good news is they don't go to a district court if they move beyond the Merit System Protections Board. They go straight to an appellate court. And so there is no role for the traditional litigation. You know, in usual federal litigation, we talk about a federal district court, then a court of appeals, and then, of course, the Supreme Court. Here, the way that the statutory scheme is set up, there is no role for the federal district court, but it will take some time. And one of the reasons that plaintiffs did try to go to courts in the first instance and not the Merit System Protections Board is because it is slower.
All right, Lisa Rubin, Yamiche Cinder, ladies, thank you very much. And next hour on Katie Tur Reports, I'll talk to the top Democrat on the Senate Intel Committee, Mark Warner, about today's contentious hearing on Capitol Hill. Also